If we go into case study 1, we'll look at the baseline trustee obligations, the duty of care, and it will look at trustee exclusion clauses across both trustees, and then looking at the settlor stroke protector liability, all within the context of investment losses, and using the Singapore Trust as the base example. Here are the questions that are going to be asked, and I think this is quite topical. We're not looking at a power holder in this, so we're not looking at settlor reserve power. We're looking at a traditional trust with a trustee and beneficiaries, and the trust holding investments at the trustee level, not through an intermediated company. And the two broad questions that I think the industry will be asking itself is, as trustee, what are my investment obligations? And can I effectively exclude liability for investment losses? In other words, what's my exposure if the fund starts to go into a negative? So that's the relationship that we're going to concentrate on, trustee and beneficiaries. And we're going to tailor this particularly to the Singapore context. So the first question, and I'll run through this and invite the panelists to then start to contribute, is this. In Singapore, we do have a statutory duty of care. Within that statutory duty of care, it's calibrated to the effective level of professionalism that the trustee has. So the duty of care of a lay individual unpaid is not the same as a trust company licensed with international operations and a heavy marketing budget. So the duty of care is calibrated in Singapore, but you can exclude the duty of care. Now, the question that comes up is this. Within the Trustee Act in Singapore, there are other obligations that are relevant to the investment of the trust fund. And I'll run through a few, and then I invite the panelists to contribute to a discussion around how these are practically being complied with in industry. So the first one is it possible to exclude the standard investment criteria under Section 5 of the Trustee Act? And we can go through when we're answering this, what that standard investment criteria is for members who are not aware of this. Can we exclude obtaining proper advice requirement when we're looking at changing the investments of the trust? And then can we exclude effectively the need to create a policy statement where we engage external asset managers to manage the trust fund? And likewise, can we exclude the duty to review the external asset manager and the policy statement from time to time? So if I may, I'll invite anyone that wishes to take this up at this point to talk about these standard provisions that are within the Trustee Act, the standard investment criteria, proper advice, policy statement, and review. Is it common that these are excluded, or is it possible to exclude these requirements under the Trustee Act? What has been your experience of a standard Singapore trust deed and the administration of the trust, where we have these trustee requirements being, or Trustee Act requirements being set out? So I think, Woonham, if you don't mind kicking us off in terms of the standard investment criteria, proper advice, policy statement, and then review. Is this something that you see habitually being done, or is it something that is effectively excluded and not followed in practice, if at all possible?
Thanks, Zach. So I'll kick off. The other panelists can jump in. So when we look at this, okay, so to answer the question, the short answer is that typically we do not exclude these duties, because the duties are actually found both in the Trustees Act as well as the common law. And then if you pay a professional trustee good fees, you do expect them to have certain amount of duties and peg that to a standard of the other licensed professional licensed trustee. So typically we act for the families. So in that case, then we will be very, very careful about what to limit and what to exclude for the trustee, because we are there to protect the family and beneficiaries. But where we act for the trustees, typically what we see are professional trustees that are licensed by the MAS, having a TCA license, and they would either act for as trustees for unit trusts, REITs, private unit trusts, ETFs, or family trusts or charitable trusts. It wouldn't be a lay trustee. So I think the Trustees Act applies to both the trustees as a lay trustee as well as professional trustees. But when you deal with a professional trustee, like I said, we pay them good fees and they're licensed by the MAS, held to a very high standard. It will be extremely difficult to try to negate or reduce some of this. So where it deals with a professional licensed manager, where in the trust deed or the settlement deed is clearly spelled out that the investment advice and the investment management is given to, say, investment committee or a licensed manager. I think that's different because that's contractual and that's clearly spelled out in the trust deed. We will approach it that way.
Right, okay. Victor, did you have any thoughts on this?
Yes, I think it's useful to first understand the common law position before looking at the specific statutory provisions, right? So under the common law position, whether it's Armitage and Nurse or Spread Trustees and Sarah Ann Hutchison, it is possible to actually reduce and actually reduce the scope of the trustee's liability even for gross negligence, right? So that's the common law position. Then if we look at the Trustees Act, Section 3A, subsection 2 specifically says in relation to statutory duty of care, that may be excluded. But there's no such express provision in relation to, for example, standard investment criteria and the other duties in the Act. So I think it's quite a gray area to say that it can be excluded. I think for standard investments, found in Section 5, I guess there's an argument, right, that if you look at the wording of subsection 5.1, it says in exercising any power of investments, it's arguable that if the trustee doesn't have that power in a reserve trust, which we'll talk about, a reserve powers trust we'll talk about later, possibly they may not have this duty. But I think as for the other powers, it is questionable whether or not they can be contracted out of. And in any event, case law makes it very clear that your core duties of carrying out the trust honestly and in good faith, you can't exclude liability for those.
Right. Okay. Lynn Chuan, did you have any views on the ability to contract out of this or otherwise, particularly with regards to policy statements and reviewing policy statements and external asset managers from time to time?
So I think firstly, I think people have said that there are no express exclusion provisions in respect of any of these things in our trustee legislation. Secondly, I agree with Vigna that in respect of the standard investment criteria, it deals with the case where the trustee is exercising his power of investment. So if it's not with him, it may not apply. But our case one assumes that the trustee is so exercising. The one point I would make is with respect to the policy statements and so on, all these provisions found in Part 4A of the Trustees Act. And the question is whether these are, although not directly stated as such, these are in fact default powers, right? So our provisions are very closely modeled on the Trustee Investment Act 2000 in England, and safe to say it was borrowed from that. So the question is really whether some of these provisions were intended to add what was not in the law as a default, but people did it in the trust instruments. So there is an argument, and I think it's a good argument that Part 4A is a default power, and if I had to be asked, I would say on balance, I think that's the right answer. And you can look at some of the English books, Kessler's, Q3's book, and so on, what views they take. So there is an argument that Part 4A is a default power. I do see in trustees that people say, the provisions of Part 4A are excluded to the maximum extent permitted by law, but I think it works. The standard investment criteria, I'm less certain. It may well apply. There are some things that you can probably shape by your trust instruments. So one of the standard investment criteria is to have diversification to the extent suitable for the circumstances of the trust, and I might put in some declaratory language to that. And similarly for proper advice, I might say, the trustee does not have to and is not intended, and that may help the trustee make a determination on reasonableness. So I'm not sure that standard investment criteria can be excluded, but on balance, arguably the Part 4A can, but it's a nice question.
Okay, and Tony, just in respect of your adherence to these Trustee Act requirements, what's your view on all of these? Are these things that we can effectively contract out of, or is it something that you are mandatorily required to follow?
I think we take the view that either you're going to be a trustee and you're going to do the things that you're supposed to be doing, or not. And I really think it's good practice to have all of these things in play. Within our context, it's exactly what we do. We do take proper advice. We do have policy statements that it's something that we adhere to.
Yeah. I mean, certainly my reading of the section, it does tether the requirements, particularly on the policy statement and the reviewing requirement, to the statutory duty of care. And the statutory duty of care, we know we can exclude that. So it does seem to suggest that we can actually free draft around this as long as we are taking care that the duty of care itself is being ameliorated at the same time. So I think it's probably on balance exactly what we've all been saying. It's pretty much up to us as how much we can try and delegate out of this through free drafting. Here's one question that comes up though in practice. Aside from all of the requirements to diversify, etc., within standard investment and advice, at the core, obviously we have a propensity to use trustee exclusion clauses within the industry. And a critical question that's being asked at the moment is this: how far can we exclude, or how effective are our exclusion clauses within the Singapore context? So the fight here is between, can we exclude all forms of negligence up until the point of willful default? And I think from the perspective of the sort of viewing audience, what we're saying here is, can we objectively exclude liability up to the point that we intentionally do something wrong against the fund, or we intentionally are reckless? And that's the dividing line. Gross negligence is, let's say, heavy amount of reckless behavior. Willful default is really, I'm taking a deliberate action and I know subjectively that this is going to damage the fund. Now, the question being asked primarily is this: can we exclude, within a Singapore law perspective, can we exclude all forms of negligence, whether gross or otherwise? And that leaves us just to have willful default as the default standard, as it were. Or are we limited in Singapore to not exclude gross negligence, whatever that means? So here's the question to all the panelists. Can we exclude gross negligence or all forms of negligence within the Singapore law context? So I think, Woon Hum, if you would kick us off again.
Sure. So if we draw from the experience and how our interaction with the regulators and the feedback we get and feel we get from them, right? So the short answer is this. We go by this standard. You can have a exclusion or limitation of liability for trustees in the trust deed. You are allowed to do that. The common law recognizes that and allows the enforcement of this. So in short, what it does is that it says that the trustee, so long as it acts in good faith, in accordance with the trust deed, then it can be excluded from liability for its acts or omission, except for 4 situations, and we call them the carve-outs. Typically, the carve-outs would be willful default, breach of trust, negligence, whether it's negligence or gross negligence, and fraud. So for these 4, in layman's term, we call them self-insured. So if your trustee are silly enough to acted or have omitted to act in one of these 4 carve-out situations, the limitation and exclusion of liability does not protect the trustee. So then the only question that sometimes is of contention is whether we could have the carve-out at gross negligence, which is high level, or just negligence. So that's a bit academic, but in the practical sense, there is a fight, right, between the trustees and the other party. And then for willful default, I think it's a given. It's a carve-out. We cannot exclude.
Right. Victor, what's your view on this? What's the standard in Singapore? Can we exclude gross negligence?
Okay. Before we talk about whether you can exclude gross negligence, I think it's quite useful to understand what gross negligence actually means, right? So common law has said that gross negligence is it's something which is more serious or more flagrant degree of negligence than just pure negligence, right? So it's something which is more serious. So I think once we understand that, we can then deal with the question. Further, in a case of spread trustees versus Sarah and Hutchison, they actually said that gross negligence does not import any question of intention or even recklessness, right? So I think it's whether recklessness falls within the ambit of gross negligence is questionable. Right? I think there's some common law authority to say that it may not. Okay, so leaving the definition aside, in my view, it's quite clear that negligence, whether it's gross or otherwise, sits on one end, which can be excluded, and bad faith, willful misconduct sits on the other end, which can't. So in my view, yes, you can exclude gross negligence.
Right. And then, Kwan, in your view, do you agree with that analysis?
Me? Yeah. I think common law, clearly you can, I think, you know, negligence, whether gross or not, you know, can be excluded. I think it's helpful if you're actually going to try and, you know, exclude, you know, certain things. Is particularly useful to define gross negligence, because there can be debate about what exactly it means. So, you know, it's useful to have a definition clause. I think Woonham talked about, you know, trust deeds. Perhaps I think more in the public space than sort of private, where, you know, you exclude, you know, breach of trust, you exclude negligence, you exclude fraud, you know, and I think from my perspective, one of the points to note about that is if you sort of carve out breach of trust from your, you know, your exclusion clause, then you've carved out arguably almost everything from the trust deed, because breach of trust can cover potentially a fairly wide range of situations. So, you know, in the private context, I would probably encourage caution, you know, before using such language.
Mm-hmm. And Tony, from your side, what do you habitually do? Do you exclude all forms of negligence and then just stay behind that willful default or fraud? Or do you import a form of negligence limitation on your exclusion clauses?
No, I mean, our exclusion clauses in terms of protection basically does exclude things. It doesn't exclude willful default, obviously, or fraud, or any of those. It also doesn't exclude gross negligence. I mean, our view is that we are professional trustees. We get paid for what we do. If we had tried to do that in terms of our client base, I'm not too sure that would necessarily be a commercially sound thing, and I'm not too sure it would actually stand up. So our trustees actually, you know, do not. But at the same time, what we do is we actually define or give gross negligence a definition, just to create some sort of substance or starting point, should that ever be an issue.
Right. But I think from a Singapore standpoint, Singapore will follow the UK side of this. And in the UK, we have this Armitage and Nurse decision, which there we had a very prominent judge grapple with this issue. And the end result was, as a matter of UK law, common law, effectively, you can exclude all forms of negligence, but obviously you can't exclude activity that's willful. So that's, if we say that that's the starting point, then we look at Commonwealth Garden Singapore Trust Deed, it can do it. And the likelihood is that Singapore court would follow the UK common law position on this. Not every jurisdiction has been the same on this, though. There's Canadian authority, there's Scottish authority that they won't allow gross negligence to be excluded. Now, the question that I think is useful for the attendees is this. If you have a Singapore trust and you have a clause within it that effectively excludes liability up until gross negligence, the question is this: from a Singapore standpoint, what is gross negligence? And I think there may be some instability in the case law. And I think, Victor, you kindly sort of elucidated some of that. One way of looking at it would be that gross negligence in the context of a licensed trust company is nothing more than professional negligence. So it would be effectively an objective standard, and not importing all of these sort of emotive terms such as recklessness or willful behavior. But yeah, I say that because it's quite an important consideration, because I think many of the Singapore trusts may carry this gross negligence limitation, as it does with Tony at Rome. and people will be asking the question, what does gross actually mean in this context? I just, Victor, on your side, having said that, looking at it from a context of a paid trustee, would you say that there is a scope for a Singapore court to equate gross negligence to effectively professional negligence and look at the objective standard of what would a professional trustee do in that situation with regards to investments, rather than looking at the reckless behavior or looking at the intention aspects?
I think it's actually a point which is, it comes down to the contractual intention for this, right? Because from a policy perspective, there's no indication that the Singapore courts would strike down a contractual agreement to limit a trustee from gross negligence, right? So we've no indication of that. So it then comes down to contractual interpretation. But this is something to think about, right? If you define gross negligence in your trust deed, but if that deviates from the common law definition of what gross negligence is, and it's drafted so widely to perhaps swing to the other side of potentially along the lines of willful misconduct, I think that there is scope for the court to go behind the contractual definition of gross negligence to see whether or not it actually strays into an area which can't be excluded.
Right, right. Okay, so I think for the attendees that are professional trustees, the question is, where are you at in terms of your exclusions? And if you have this gross negligence term in there, there is some level of instability on the scope of that potentially. So this informs you that this is an area in common law that is not solid in stone in terms of the interpretation. I think one final point on this is with regards, we have this phenomena of having a duty to inform, and I think STEP have done this in the UK, where you include an exclusion clause, and I think the new New Zealand Trust Act takes this much further, that where you have an exclusion clause within the deed, that you ought to bring this to the attention of the settlor and setting up the trust. And the question I'd ask the panelists is, from a Singapore standpoint, do we actually need to tell the settlor we are excluding up all negligence, or we're excluding up until gross negligence? Or what is the position here if we don't do that? Should we be saying to settlors, this particular clause you need to be very careful of, and we need you to be proof that you're cognizant of the sort of limitations on our liabilities? So I don't put this up to Lin Chuan, if you could kick off on this one, on the duty to inform the settlor. Does that exist under Singapore law?
I don't think there's a hard duty, but as a matter of sound practice, and as part of explaining the trust deed, I think this is certainly one of the clauses that would be very high up on the list of things to draw the party's attention to.
And does everyone else agree with that analysis? That as a matter of Singapore law, we don't have a duty to do this, but it's good practice. It's good to do it.
I would agree with Len Chuan's position. And I think in practice, some trustees may not actually be highlighting that clause. Yeah? And if there's ever a dispute that goes to the courts and there's an issue of sort of reasonableness and relying on the exclusion clause, from an evidentiary perspective, it can be proven that right at the onset it was highlighted. I think that would be very useful.
Right, right. Will, have any comments on this?
I don't believe that there is a Singapore legal position on this, or that there's a duty to inform the settlor. When we act for the trustees, the professional trustees, we do advise them to highlight this out of good practice. If we act for the family, we will zero in on this, like Lin Chuan said, it's actually quite high on the list.
Right.
So limitation of liability, exclusion, duties of express duties and implied duties of the trustees. These are actually, like the top 3, top 5.
Right, right. And Tony, on your side, what's the standard practice at Roan when it comes to these exclusion clauses?
I mean, we don't formally highlight them. We don't make a settlor sign off on on having been made aware of that. I am conscious of the fact that some trust companies do that. We do have a summary of the clauses. It's a 2-3 page, little summary that just highlights it. But from a client acceptance perspective, we always have to satisfy ourselves that the clients have actually been adequately advised before we actually take over as the trustee. And so therefore, from that perspective, there'll always be a legal advisor on the side of the client or the settlor who's actually should be, highlighting that.
Right.
But I do agree that it is something that would be good practice.
Yeah, okay. So I think the key takeaway is for these sign-off provisions, if you're a professional trustee and you haven't been doing this habitually, then it ought not to prejudice your clause. In other jurisdictions, it will have prejudiced your clause. But in Singapore, that's not the case as the law currently stands. I think that's the consensus.